I'm Steve Wilkerson, and I'm with Jim Saunders, Executive Editor of the News Service of Florida. Jim, since the legislature has left town for the session, 2015 session, there have been a lot of actions in Florida courts, some of them about legislation that just passed the Florida legislature. Let's discuss, first of all, the legislation requiring a 24-hour waiting period before women can get an abortion in Florida. What's happening with that?
The legislature, the Republican legislature, overwhelmingly passed this bill during the regular session this year to require 24-hour waiting periods before women could have abortions. And it was pretty controversial during the session, despite the fact that it passed so overwhelmingly. And immediately, when Governor Scott signed the bill, the ACLU and another group filed a lawsuit seeking an injunction and challenging the constitutionality of this law. There was a lot of debate during the session about whether this was constitutional, and the critics of the bill said that Florida has a strict privacy provision in its constitution, and that this bill would violate that provision.
That provision, the privacy provision, apparently I've been told is somewhat stricter than the national constitutional protection.
It is, and it also has come into play several times in major abortion-related cases in the past. And it has frustrated the pro-life side because it has made it harder to pass restrictions on abortions. This lawsuit was filed in Leon County Circuit Court seeking an injunction against the 24-hour waiting period, and a circuit judge granted that. And so the law, the newly passed law, is now on hold, not being enforced, and the privacy issue is a main part of that case. The critics of that bill argued throughout the legislative session that requiring 24-hour waits was not only unusual, the legislature just doesn't mandate 24-hour waits for other types of procedures, but also a major part of that argument was that low-income women, women who live in rural areas, would have to make 2 trips to an abortion clinic if they want to have an abortion, and as a result, that would place a hardship on those women, particularly from rural areas who may have to travel long distances to an abortion clinic. The proponents of that bill said that 24 hours is a time of reflection, and if women are going to have abortions, they need to take that time to make sure they want to go through with this procedure. But the judge put in place, enjoined it, and it is not going forward at this point, although the state has already filed a notice of appeal to the First District Court of Appeal to try to take the case up there and get the circuit judge overturned.
Another law that actually was a constitutional amendment that came up during the session had to do with Amendment 1, which set aside tax revenues from dock stamps in the state, adding up to several $100 million a year for the purchase of endangered lands that had to do with water management. And the people who worked very hard in their minds to get that passed do not feel that the legislature set aside enough money to purchase those kinds of lands for that kind of water management. So they filed suit. Tell us about that.
Again, this suit was filed pretty quickly after the legislature approved the budget, which is where a lot of this activity, if you will, or how the Amendment 1 the money is parceled out. The proponents of Amendment 1, which passed overwhelmingly last November, say that the voters thought they were voting for the legislature and the state to set aside money each year for large amounts of land acquisition and conservation. And the legislature looked at the amendment, and they kind of divvied up the money other ways. For one thing, legislative leaders argued that the state already has, some of them argued the state already has enough land under its control, and the problem is management of the land as opposed to buying more land. So the lawsuit was filed essentially arguing the legislature did not follow the will of the voters. Part of the issue here too, though, is that money was set aside by the legislature from the amendment to pay for things like agency expenses, Department of Environmental Protection, agency expenses, ongoing expenses. So the proponents of the amendment say that's not what the amendment was about. It was about conserving land and water. The legislative leadership has said for months that they've read the amendment and they've read the text of the amendment, and what they're doing follows the text of the amendment. I think the proponents argue that they may be following the text, but they're not following the will of the voters. That case is pending in Leon County Circuit Court, so we don't know where it's going to go. I think the proponents of the amendment have even acknowledged at this point this is probably not going to change anything for this current budget year, which started July 1st, but it's more of a long-term focused lawsuit to try to, because this amendment lasts for 20 years, the requirements of spending this money last for 20 years, that they're trying to get some sort of judicial ruling at the, going forward so that the legislature will do as they wish and not as the legislature wishes necessarily.
Well, it's a multi-billion-dollar issue.
It is a $700 million a year at this point.
How many years?
20 years.
20 years.
So it's a lot of money we're talking about. Now, not all that's new money because some of that money was going to environmental programs already, but it's roughly, the new money is about $250 million a year for 20 years. So we're talking a considerable amount of money at stake here.
Another far-reaching lawsuit brought by the League of Women Voters and a coalition of other interests is challenging the Florida legislature's congressional redistricting plan. It's already been in court, and a judge has said that the current configuration is okay, but it's been challenged again. And it could, if the current plan was thrown out, it could have far-reaching implications. So where is that?
This case could be decided by the Supreme Court as early as this week.
This is the Florida Supreme Court.
The Florida Supreme Court. As we sit here today, it has not been. But there is speculation that it could come in a matter of days. And what it results from is, as you indicated, Leon County Circuit Judge Terry Lewis held a trial on this issue and ruled that the legislature had violated a constitutional amendment that passed several years ago. And that constitutional amendment was directed at no longer having gerrymandering in congressional districts as well as legislative districts. Now, this case is only about congressional districts, but Lewis argued that 2 districts were unconstitutional. Those districts are held by Corrine Brown, a Jacksonville Democrat whose district runs in a strange shape from Jacksonville to Orlando, picking up a lot of minority voters and Democratic voters. And then another district that's represented by U.S. Representative Dan Webster. Again, that's in the Orlando area. Lewis found that those districts were unconstitutionally drawn under this constitutional amendment that was passed. And the legislature came back in, redrew those 2 districts, which naturally has spillover effect in the neighboring districts. But when they redrew the districts, they went back to Lewis, and Lewis signed off on those districts. The League of Women Voters and these other groups then challenged the map again at the Supreme Court. They were not happy with what they call relatively minor changes that were made to fix the original.
Kind of like tinkering.
Tinkering with the Lewis,
they would say.
What Lewis found problems with originally. So the case now at the Florida Supreme Court, and the League of Women Voters and these other groups, they're looking for a pretty major redrawing of the congressional map. And not just these 2 districts, they're looking for other changes. And if the Supreme Court agrees with these groups, like you said, it could have major ramifications because the legislature would have to come back, presumably, and redraw the districts again. And we are now, while it may seem a long ways out, we're little more than a year out from the primaries and less than a year out from qualifying for congressional races. So, things would have to happen fairly fast. It could change a lot of the, it could affect a lot of incumbents, but also change a lot of the dynamics that go into candidates deciding whether they're going to run. If the Florida Supreme Court signs off on what Lewis's ruling was, things probably will move forward fairly smoothly. But there's a lot of scrutiny of this case right now, and a lot of speculation about what would happen if the Supreme Court strikes down the districts.
Any impact on state redistricting of legislative races?
Not at this point, but there's another pending case in Leon County Circuit Court that challenges state Senate districts under this, what they call the Fair Districts Amendment, this constitutional amendment. That I believe, is ready to go to trial in September. So that also is going to be very closely watched. And frankly, in Tallahassee, maybe watched more closely than even the congressional race, or congressional seats, because it's a state Senate. It would have a major impact in the Capitol if indeed those districts are thrown out.
Thank you, Jim. For more news about Florida politics and government, visit the Advances section of our website.